Now, these are important to make sure you put sufficient information on your situation. We don't know what that is, yeah? But you need to make sure that you put enough information on the form about how you've suffered loss and how you've been impacted. Don't try and do a one-liner. Okay? Try and put more information, because when the caseworkers are reading your application, that information is important that you have conveyed a reflection of what has happened to you over many years. And we say this, if you're having a difficulty in reading the guidance and completing the application yourself, do seek some help. And this is where our advocacy service comes in, or somebody who can help you. It could be a family member, it could be a friend, somebody that is familiar with this. Maybe they've made an application themselves before and they understand what needs to be done. It is also good practice to make rough copies. The same way when you're doing your essay, you do several drafting of your essay before your final copy is submitted. That is important because you will forget things, and when you make several copies, you're trying to remember as much as you can of your situation. And when you finish the final drafting of your responses, get somebody to have a look at it, okay? To have a look at it and read it through. And when that individual is having a look at it and reading through, some other points might come out that you omitted. So use that process before your final copy that is going to be ready to be sent off to the Home Office. Very important. If you make a mistake in writing any answers, just put a single line through it. Don't keep scribbling over and over. Single line and then put the correct answer. Again, the guidance tell you all of this. Okay? It's important to follow the guidance at every stage of your application, whether that is primary, close family, or deceased, which we'll come on to those in a moment. Follow the guidance. Don't try to put things on paper without consulting the guidance. Very important. We know it is the case where individuals have completed an application by themselves and send it into the Home Office. And often the award is nil because they've omitted some very important information that should have been included and they didn't do it. Yeah. That is why it's important to talk with other people. Talk with other people, whether in your family or friends, or again, as we said, the independent advocate that can assist you and help you with the process. And the advocate service, there is no charge to assist you with your application. In the chat, I've put the contact information as to where you can locate the advocate on the liverpooladvocatesforwindrush.org. The website, you have telephone number, email address, and individual names that you can contact, reach out. And it doesn't matter where you are located in the country, the advocate service will be there to assist you. Okay? So please reach out to Law Liverpool Advocates for Windrush. So this is about the primary claimant making the application, consulting the guidance, and completing the application, and then checking the application, right, before submitting the application to the Home Office. It makes good sense to check after you've completed it to make sure everything is correct. And as I said, get somebody to have a look at your application before you submit it so that everything is included as to your situation and what losses you have suffered. Okay? So that's primary claimant. We're going to move now to another part of claim known as close family. Close family member claim applies to individuals who have assisted and support a close family claim. Is the primary claimant getting support from other members of the family. There is no number limited as to how many people can support a primary claimant. Whether it is 4, 5, 6, 7, 8, 9, 10, it doesn't matter about the numbers. And we must emphasize that the award for close family does not affect the primary claimant money. So whatever sum of money will be awarded to the primary claimant as compensation, the close family claim is a separate pot of money. It will not come out of the primary claimant award. So don't think if I make a close family claim, I'm going to reduce the money that the primary claimant will be getting. That is not the case. Okay? We are stressing there need to be more close family members claim because we know that many family members and friends have been supporting individual for a number of years. So they need to step up and come forward and make a claim for supporting those individuals. I'm going to bring Roland in now just to explain close family claim and what we mean by close family. How do we define a close family claim? Roland?
Okay, good afternoon again. Can you hear me okay?
Yes, go ahead, please.
Okay. So Garrick just explained the primary claim and the deceased estate claim. And just for clarification, there's absolutely no difference between a primary claim and a close family member claim, except that that individual that would have been eligible and entitled as a primary claimant is now deceased. So that's a deceased estate claim, eligibility, entitlement, etc., etc. With the deceased estate claim, there's a process. Can you mute that, please? With a deceased estate claim, you have to go through a process of probate, and that is to establish that you are the right person, the correct person to submit that claim. Once that primary claimant has passed and become a deceased estate claim, is either the executor of the estate, or the next of kin that will submit a deceased estate claim. Close family member claim. In order to be eligible to make a close family member claim, you need to be a close family member to the primary claimant or the deceased individual. For which close family members are we talking about? It's a specific group of close family members. And it's as follows. Wife or husband of the deceased or the primary claimant, parent of, children of, siblings, brothers and sisters, anyone that lived in a relationship with the primary claimant or the deceased individual for 2 years or more, and was lawfully in the UK at the time, and also make a claim. And sixthly, stepchildren, as of the 23rd of April this year, stepchildren and step-parent can also make a claim as a close family member. In order to make a claim as a close family member, you don't need to have supported the primary claimant financially. There are two elements to the close family member claim. There is impact on life, how you, the close family member, was impacted emotionally, anxiety, stress, inconvenience, etc., etc. And there is also the living expenses element of it. And that living expenses to do with how you supported them financially. You pay the rent, buy them food, give them money, buy them phone cards, etc., etc. Living expenses, and it means exactly what it says on the tin, living expenses. You spend money on them, or you may have invited them into your home. Consequently, your gas bill, electric bill, etc., utility bills went up. You have to be washing for them. There is no limit on the amount of close family member claims that can be submitted. It did not say to a maximum of 10 or maximum of 50 or whatever. So if there's let's say you've got the primary claimant or the deceased individual has got 12 children, 12 brothers and sisters, 12 siblings. Fortunate enough that their parents are still alive and they were married. And also, just before, if it's a deceased estate claim, just before the past, they got involved in another relationship because they got divorced due to what they went through or was going through. The marriage broke down. So that you'll have 12 sibling claim. 12 brothers and sisters will make a claim on the back of the deceased estate claim. Also, the 12 children, the mother and the father as well, are his parents. Also, the former ex-wife or husband, former wife or husband can also make a claim. And also, in this particular situation, the impact on the primary claimant or the now deceased primary claimant, who is now deceased, got involved in a relationship 2 years into this impact, which lasted 7, 8, or 9 years old. 2 years before 9 years, 2 years before the past, he got involved in another relationship. Likewise, that individual, that partner, whether man, female, doesn't make any difference, can make a claim as well. So you have over 15, 17, 18, 20 claims. Each claim would be claimed within their own right. It's how you, the individual, was impacted. Or you, the sister, or brother, mother, father, wife, husband, or partner, was impacted due to what you saw the primary claimant or the deceased individual going through. How you impacted emotionally, anxiety, stress, etc., etc. How you were inconvenienced. You wanted to go on holiday with that particular individual, primary claimant, but due to the fact that individual did not have the British passport, or for whatever reason, you could not go on holiday with them. You were inconvenienced. You were inconvenienced. You saw them crying every day, stressed out, etc., etc. That caused you to be stressed as well. You, the close family member, could be stressed to the extent that you may have got to go and see a doctor, speak with your GP or counselor or whatever about what you saw your mother, your father, primary claimant going through at the time they were going through the struggles. There is a misconception that the close family member claim is an inferior claim, so to speak, because it's a close family member claim. That is not necessarily the case. There are cases where the close family member impact is more prolonged and more severe than the primary claimant. The close family member is more severely impacted than the primary claimant. And I'll give you an example. One particular case, lady came here 60s. In the 1960s, worked for the NHS. Went on holiday to Ghana. Whilst in Ghana on holiday, her daughter had an issue in the UK and she needed to return from Ghana back to the UK. Due to the Home Office incompetence, maladministration, whatever, she was out of the UK for about 3 months, this lady. While she was out of the UK for 3 months, her daughter had a nervous breakdown. Delayed getting back to the UK, didn't get back to the UK until 3 months later. Due to that impact, that 3 month time she was out of this lady was out of the UK, that daughter ended up in a mental institution. And that got into all the details and all the intricacies, but that was down to the Home Office. It was their fault. So in that case, the primary claimant that was locked out of the UK was not as severely impacted as the close family member, her daughter, was impacted. There are cases where, and you can have more than one, a close family member can have more than one claim, because if there are more than one primary claimant, i.e., give you an example, the same case as well. The mother was impacted, the son was impacted. This mother had a number of siblings, a number of brothers and sisters. This mother also had 3 children. The son was impacted, so the son submitted a primary claim. The mother also submitted a primary claim. The mother made a close family member claim against the son's claim. The son made a close family member claim against his mother's claim. Vice versa, they claim each on the back of each other's primary claim. The daughter made a claim against the son's claim, which is her brother. And the daughter also made a claim against the mother's claim. I've got another case where a deceased estate claim and the children submitted a deceased estate claim. Once an offer was made on the deceased estate claim, the children start submitting close family member claim against the deceased estate claim. The sibling of the deceased individual submitted a number of close family members of claim as well, with them being the close family member, the siblings of the deceased. Mother submitted a claim as well. When the mother submitted her claim, the mother of the deceased submitted her claim and put her impact and life statement in, the Windrush scheme came back to her and said to her, based on what you said in your statement, you too has got a primary claim. Also, they say the same thing to the children of one of the son of the deceased individual. What that did, it triggered a number of close family member claim on the back of the son claim, the son of the deceased, and it also triggered a number of close family member claims on the back of the mother's claim, which is the mother of the deceased individual. So the siblings of this deceased individual had 2 claims running, close family member claim and the children of the deceased individual had two close family member claims, one against the deceased father and one against that brother, the son of the deceased individual. Once the claim has been submitted, the primary claim as a deceased estate claim has been submitted, what I suggest is do not submit the close family member claim until an offer has been made, whether it be a preliminary payment, which is 10,000, where we'll write to you and say, based on the impact on life or based on the checks that we have done, it has been established that this claim, this deceased individual, deceased estate claim, or this primary claim would be entitled to some compensation. However, we're going to continue to assess this claim, but in the interim, here is 10,000, so to speak, to continue living on. Or they may make an offer outright. Once either of those have happened, either preliminary offer, 10,000, or an outright offer, even if it's the minimum of 10,000, once you've gotten to that point, it is at that point the close family member claim should be triggered. You start submitting the close family member claim at that point. You don't want to be submitting numerous close family member claims and then the Home Office or the Windrush scheme come back and say there's a nil offer. The primary claimant or the deceased estate claim needs to make an offer for the close family member claim to be valid. When the close family member claims are being submitted, I always suggest that the close family members be speaking to each other. These children, these brothers and sisters, all to be speaking to each other. So if it's a deceased estate claim, the children of the deceased individual should be speaking among themselves. Likewise, they should be speaking to the sibling of the individual that has passed. So these siblings would be the aunts and uncles of the children. Need to be having that discussion, because even in fact at the stage when the deceased estate claim is going to be submitted, our primary claim, each one should be speaking to each other, because in some cases, in many cases, the information could be spread across the different close family members, the siblings, children, etc. One may have a bit of information when dad or granddad went to Ghana and he was stopped at the airport for half an hour or more, or when he was working at a particular place and he was asked to bring in the documentation. He may have just shared that information with one particular individual, one of his siblings or their sibling or one of the children, or that one that went to the airport to pick her up from the airport when she was returning from Kenya. When she went to Kenya on holiday, she just shared the story in the car from Heathrow to the way up to Bradford. The story may not reach back in the house. By the time they get back to the house, they're talking about what a great and wonderful holiday it was in Zimbabwe, meeting her children, etc., etc. Sorry, her siblings, her brothers and sisters that she have not seen for so many years. Very important to have that discussion among the close family members. I always say this, in many families, if not most families, you've got one particular individual that appoint themselves as the family accountant, the family lawyer, the family librarian, and anytime you need any particular piece of documentation, whether it be death certificate, birth certificate, and so on, you've got to go down on your knees and beg that particular individual, please, can I have mom's death certificate or birth certificate or marriage certificate? And they will give you a long string of excuses why you should not have it. In this particular case, when claims are being made to the Windrush compensation scheme, that is going to put that particular accountant and librarian at a disadvantage, and everyone else that intends to submit a close family member claim needs to be forthright, needs to be transparent with information, documentation, etc., etc. Some of the documentation you may need depending on the close family member that's going to make the claim. If it's the wife of the deceased individual, that wife need to submit, our husband is going to need to submit the marriage certificate to establish the relationship between they had prior to that individual passing. Or if it was a situation where they're cohabiting 2 years or more, etc., they may need to show proof of address 2-3 years ago, whatever, to establish that they were actually living together as wife or husband. Letters from benefit agencies, etc. If you are the son and daughter of the primary claimant or the deceased individual, you just saying it's my dad or my mother, it's not good, that's not going to cut it. You need to supply a birth certificate to establish the relation between you and that primary claimant or the deceased individual. I've come across cases where mother does not want to share information with the daughter, so the daughter don't even know if her father was divorced from her mother before the passing. So that is the level of lunacy that you'll find in many families. They don't speak to each other, and this is the Windrush compensation scheme. It's on the chart. The way we present information here, it may not be the way you used to hearing it on other platforms. There are many cases where individuals do not speak to that one. I do not speak to him because he's a Rasta. I wear a particular clothes. I should cream her hair or whatever. I should go to dance hall or listen to a particular. This is not the time for that. You need to be forthright. You need to give that information and share the information among yourself. If you don't do that, it's gonna slow the whole process down. In terms of timeline, just to give you an indication as to the timeline once you've got all the documentation together. I'm not saying it's gonna be this in all cases. I've had cases where on a close family member claim, in fact, the primary claim as well, we have had returned within 42 days because I submitted the birth certificate, the passport, the proof of address, the proof of ID, submit the statement that is clear and concise about what happened to the primary claimant or the deceased individual. And it's not about volume, it's not about the amount of information, it's about the quality of information. And you're not doing an exercise in creative writing. Just be clear, be concise, and speak in your own tone, so to speak. Mother came to the UK 1967 from Sierra Leone. She worked at ABC 123 right until 1987. 2014 or whenever. In 2014, 2015, she was asked to bring in her Sierra Leonean passport, Botswanian passport. She brought the passport in, but that particular passport was a new passport because she traveled there a few months before, and she did not have the whole passport with the indefinite leave to remain. She took the passport in, and the employer did not accept it. They called the Home Office. The Home Office said she was not allowed to work in the UK because her name was Rickard, Rickard. However, the Home Office thought it was Richard, and that K was replaced with an H. So when the employer called the Home Office, computer says, no, you're not allowed to work in the UK. As a result of that, mom's mortgage went up. Consequently, the house was repossessed and we had to sell the home. I was living there with my 3-4 brothers and sisters. Likewise, the grandchildren living here. We all lost our home. As clear as and concise as that. Don't need to be long and elaborate, and do not drift off at a tangent. Speak specifically about what is relevant to what happened. It's an impact on life statement here you're submitting. It's about specifically, not your feelings about the Home Office, not your feelings about what went on the plantation 400 years ago. It's not an opportunity to vent. Just say, be concise, be clear, and be specific. And if you can write in Keep it contiguous, means make sure it joined up, so to speak, make sure it's relevant, and you don't drift all over the place, back and forth. If we can write it in sequence, when it happened, this happened, then that happened, and so on and so forth. Keep it simple and straightforward. And back to Garrick at this, I've submitted numerous close family member claims, and I've had numerous offers from these claims. In terms of numbers, because I know many of you may want to know this, the average that is paid out, if based on the caseworker's guidance, if it lasts, say, a week or so, you're talking 10,000. Weeks leading into months is around about 20,000. If it was you were impacted as a close family member to the extent that you went and see the doctor, speak to the doctor a couple of times, that may be around about the 40,000 ball figure, roundabout. That's that's a level 3 claim. If you spoke to the doctor then, a couple of years ago, and you're still speaking to the doctor now, and maybe have to add some medication, that's another indicator, we're talking 70,000. If you spoke to the doctor then, still speaking to the doctor now, and between then and now, you were impacted to the extent due to what you saw your brother, sister, mother, whomever going through, that you had to stop from work, lost your job, etc., or you too may have slipped into depression. It's 100,000 and above. If you have a level 1, 10,000, level 2, 20, level 3, 40,000, level 4 is 70, level 5 is 100,000, and in extreme cases, it's over 100,000. That is impact on life. Now, talking about you losing your job. Specifically, impact on life is all your inconvenience, stress, anxiety, emotions, etc., etc. That is what impact on life is. Loss of earnings, that's different. You claim for when the impact started, when you were not allowed to work. That's when the clock starts, so to speak, i.e., if you were earning 20,000 per annum and you were not allowed to work for 3 years, 3 multiplied by 20 is 60. That means you should be claiming 60,000 or above, because it said 3 months or some point after you got documentation to prove that you've got a right to work. Now, in many cases, what the Home Office is doing, or what the team is doing, compensation team, they are making offers, even when the impact lasts for more than weeks going into months, 3, 4 months, 9 months. They're sending you offers out for 10,000. Very good for you not only to understand the guidance note for the particular category of claim, whether it be primary claim, deceased estate claim, and in this case, close family member claim. For you to understand clearly that when they send you an offer out for 10,000, and you know from June 1999 or June 2019, right up to April 2020, 7, 8, 9 months, that individual couldn't get the passport, was going back and forth to the Home Office, that goes into months. That means they should not be offering you 10,000. That should be taken into the 20,000 ballpark, so to speak. You went and see a doctor and are speaking to your doctor because what you saw your brother going through, been to the doctor a number of times, you should be thinking in the 40,000. So if they send 10,000 to you, right, and you're asking for a tier 1 review, few sentences, based on what it says in the caseworker guidance, I should be compensated at 40,000 because this is what it says here, and it's basic and straightforward. Open quotation mark, copy directly from the caseworker guidance, stick it there, close quote, quotation, based on what the caseworker says above, as stated there, I should be compensated at this level because it lasted for months, not weeks, and I had to go see my doctor, and I also was on medication. Yeah, just obviously, I'm talking in snippets. at this point, I'll hand back to you, Gary. If anyone would like to ask any
Thank you
question
very much for that,
or
Roland.
for any elaboration, then I'm here. Thank you very much for
Yeah, that's okay. Thanks. So we're discussing close family claim. There's a lot of information that Roland has just given. Let me just pick out some of the key elements that we need to be aware of. And 2 points. The close family guidance is 24 pages. And we've said that each claim comes with its own guidance. Primary is 44 pages. Close family is 24. It's important that you read the guidance. Roland also mentioned the caseworker's guidance. That's a much bigger document, over 100 pages. But that document is important because that is a document that the caseworkers will be using to assess your claim. So if you're not familiar with that document and they offer you 10,000 because you don't know any different, you're going to accept it. But if you have read the document, and as Roland mentioned, it states here, and you can quote that reference because you've read it, then you can challenge the offer that's been made to you. Now, when we talk about close family, this is a claim that we are pushing because these claims are easy to administer. And as Roland said, once the primary claimant has made an offer, whatever offer that is, whether it is the initial offer of 10,000, once you get that letter of offer to the primary claimant, then any close family claim is ready for submitting. But it's also important that you have a conversation with the primary claimant, because the Home Office is going to try and establish the relationship between you, close family, and the primary claimant. So these conversations should be taking place before you make your claim. And this is why Roland mentioned it's important that family members talk to each other. Don't try and hide, because you don't want other family members to know what you get. It's important that you have these conversations because the primary claim offer is triggered, and then that is a green light for close family claims. Very important. And again, you do not have to accept the first offer. And again, you have to be familiar with the casework guidance. It is a lot of reading. Not everybody can read through 44 pages of document or 100 pages of document and keep that information in your head. And that is why we suggest you seek some help. Yeah? Somebody with the experience who've made a claim, or reach out to any of the advocates that can help you with your application, with your claim. Very important. And we keep stressing this. Each of the claims, there is guidance. So the close family guidance, the deceased estate guidance, it's all there. Must consult it. Don't just start to write things down without you consulting the guidance. And it was stressed there is no fixed number of close family claim. It doesn't say you can have to the maximum of 10. It doesn't say that. Yeah? As many as necessary. And the most important thing is establishing that relationship that the close family claim had with the primary claimant. Notice the point? Let me repeat again. Establishing that relationship that the close family members have with the primary claimant. It should not be the case where they don't know each other, because the Home Office will be establishing that relationship. Yeah, who it is, you know, oh, my uncle, my auntie, my sister, my brother. You're going to be establishing who is these close family, what relationship they have with the primary claimant. You can't just make something up. It has to be established and evidence. And again, the guidance is going to help you to arrive at the right decision so you know what you're putting on paper. If you're having difficulty understanding all of that, all of the guidance, you might have some learning disability issues, you might be dyslexic, whatever it may suffer from autism, whatever it may be, and you need some help, then reach out to get the necessary help. The Home Office also have a vulnerable person department to assist individuals who are vulnerable, whether that will be a physical issue or an emotional, psychological issue. If somebody can help you and assist you. Okay? So it doesn't matter what state you're in, help is available with your claim. So we've done primary claimant and we've done close family, and we refer to deceased estate. There is no difference between deceased estate and primary claimant because they were both eligible, but one died before able to put the claim in, and other family member will continue the claim, will submit the claim on behalf of the deceased person. And Roland mentioned we have to establish that the person has actually died, so we need a death certificate. The Home Office will assist individual to get the necessary legal evidence, documentation to confirm that the person died, not in this country, the person is outside the UK, up to £1,500 payable to assist the documentation, probate, etc. So the individual do not have to cover the cost themselves. And don't worry about having to pay in advance and then claim it back because you don't have the funds to pay in advance. No, you contact the necessary equivalent to a solicitor in that country, and that information is then passed on to the Home Office, and the Home Office will pay directly to the individual organization who are providing the evidence. So if it's a lawyer, etc., providing evidence, they will be paid directly without you having to worry about that money. Okay? So that is the evidence that's required to prove that the person really has died, not gone into hiding, the person have died. We've got the evidence to confirm this. The person died in Sierra Leone in 1967. Here is a death certificate to confirm that. Okay. Those are the sort of evidence that's required. Okay. So we've done each of the claim. I just want to come back to something that we started with. And there are people who have left the UK for a number of reasons. They may have gone to visit a family member or to care for a family member who is sick. And having gone and spent some time, a period has lapsed, a period of 2 years of lapse, and they're not able to re-enter the UK. What will happen to those individuals? We sometimes hear the expression locked out of the UK, cannot re-enter. We've been successful, Justice for Windrush Generation, successful in assisting individual to come back to the UK after being out of the UK for many years. So, this is what the guidance says. If you've been living in the UK continuously or have the right of abode, you can apply for the following: British citizenship, evidence you have the right of abode, a document confirming you have indefinite leave to remain. If you left the UK for more than 2 years and come back, so listen carefully. If you've been away from the UK for more than 2 years, 2 years and 1 day, you can't re-enter. 2 years and 1 day. Now, European people can travel out of the UK for up to 5 years. They can be away from the UK for up to 5 years and return within that 5-year period, no issue at all. But it's not the case for people from the Commonwealth. If you've been away for 2 years or more, at some point are now lawfully in the UK, you might be entitled, listen, you might be entitled to indefinite leave to remain. If you already have indefinite leave to remain, you might be able to apply for a document to prove you have the right to be a British citizen. I'm just going to ask Roland to come in on this point in terms of people who have expired the 2 year and are still trapped outside the UK. Roland, can you say something about this?
Yeah, I'm going to make it snappy because I think at this point you should give the opportunity for anyone to ask any questions.
Yes, please.
Yeah, so you had indefinite leave to remain because you entered the UK before the 1st of January 1973 from a Commonwealth country, etc., etc. You've left the UK and been out of the UK for 2 years or more. Your indefinite leave to remain would have lapsed. You can apply to the Windrush scheme to resolve that issue. If you've got strong and continuous ties to the UK, that's one of the criteria. Strong and continuous ties could be one of the following. You've got children here, siblings, brothers or sisters, or children here, or you've got business in the UK. You can submit an application to return to the UK. You can submit an application for a return resident visa and continue living in the UK as you were living before. There's a bit more to it than that, but that is the synopsis. You lost your indefinite leave to remain lapsed due to the fact that you're out of the UK for more than 2 years. you've got a strong and continuous ties to the UK, brothers, sisters, children, etc., or a business, then you can apply for a return resident visa to
Yes. And
get
we've
into
been
the UK.
successful. We've been
Yeah.
successful in assisting individual to actually return using that process.
If there are any questions at this point, I think we should raise your hand, the digital hand, or your physical hand. And
So we've
ask the
covered
question, please.
primary claimant, close family, and deceased. Is there anything, any question relating to any of those points that we've covered, that any clarification is required? We don't want individual to speak about their personal situation. That can be done offline by reaching out to the contact information that we will give you at the end of the session. If you need to talk one-to-one about your particular situation. But if there's a general question relating to what have been presented, please do ask a question. Either raise your hand or use the digital hand, or maybe in the chat. If Mimi like to have a look, anything in the chat that somebody want to raise. We have 10 minutes for Q&A bit now before we do our final summing up and what's on.
No, I don't see anybody added anything.
Okay. So
Just
I'm assuming then that the information that we have presented, and again, let me go back to the reference point. So the primary claimant guidance is 44 pages, and the close family is 42. The caseworker's guidance over 100 pages. All the information that we present can be found on .gov.uk/Windrush compensation scheme. You can find all of this there. And when you get onto the Home Office site, you then have a choice of the different areas that you can focus on: primary claimant, close family, deceased. So .gov.uk/Windrush compensation scheme will give you access to all the information that we have spoke about today. Primary claimant, close family, deceased, who is eligible, it's all there. Yeah? It will also give you any updates, anything that has been released on the what we call fact sheet. Yeah. So you can then Google fact sheet and it will give you anything new that has come out. And each quarter, the Home Office releases data on how many claims have been received and what has been paid out. And I just had a look today. The quarter for May is now out. So the document that tells you about May, the data is out in the public domain. We don't know the different region as to where claim is coming from. The Home Office doesn't give us that information. We don't know, for example, in Birmingham, there is 10,000 claimants. We haven't got that information. What we have is country from A to Z. So you will have country with how many claims has come from each country. And when you have a look at that data, you'll be surprised to know the highest number of claims has come from the EU. And the reason for that is that following Brexit, EU national that was residing and live in the UK up to 1988 were eligible to apply to the scheme. So that's what they've done. they have rectified their status, they've applied to the scheme, and there are over 4,600 claims for EU. Then the next figure that you will see in that follow the EU is the claim from Jamaica. And the claim from Jamaica is just over 3,000 claimants. You would expect that to be the highest claim, but it's not. And then you'll find, as you look down, you will see other claimants like India, Ghana, Nigeria, Bangladesh. You'll see all these countries, and then you will see something called rest of the world. Okay? So that will give you a running total of how many people have claimed using the Windrush compensation scheme. We're still concerned that many people are not coming forward to apply to the scheme, and we've expressed this to the Home Office only last week in Ipswich, and it was stated there the fear why people are not coming forward. People don't know whether they will be dealt with fairly. They don't know whether they're going to be, identified to be deported if they come forward. These are issues for the Home Office, and these are real issues that is affecting the numbers of people coming forward and making a claim. We continue to challenge the Home Office because, we don't believe that they're doing enough to make sure the information about claimant is published. And we also are concerned that people from outside the UK haven't got the same access to information that those in the UK have. And we have stressed this to the Home Office, that they need to do more to reach out to people outside the UK. And that is something that we will continue to do, because we don't think it's the fair process for those who are locked out of the UK, not able to have access to information as we have in the UK. Roland?
Let's clear something there, please. There are a number of false narratives out there and misunderstanding to a great extent. One of them is that if you're on benefit, working tax credit, child's benefit, etc., then claiming to the Windrush compensation scheme will impact your eligibility to get those benefits. That is not the case. If you make an application as a close family member, primary claimant, or whichever, and let's say you even compensated 100,000, and tomorrow you want to claim any benefit, that 100,000 should not be taken into account. If you got 100,000 compensation and you had 10,000 in saving outside of that, you'll have 110,000 in your account. The 100,000 should not be taken into account. The 10,000, yes, because that did not come from the Windrush compensation scheme. However, that 100,000, even if it's 300,000, should not be taken into account. That is actually stipulated in the guidance. If you know of anyone who has claimed compensation from the Windrush scheme and they were denied benefit, DHS benefit, SS benefit, due to the fact that they had that money in their account, they had that money, then please let me know about it, because it should not be taken into account. Because
just keep talking, Roland. Talk about pension. I'm just going to go to the bathroom and come back. Just mention pension,
the
please.
Home Office. I'm glad you mentioned pension. As of the 29th of December last year, those individuals who lost out on their pension, national insurance contribution, it will be reinstated proportionately to the amount that was lost. So for let's say for 5 years, you were not allowed to work, then there was a 5 years of national insurance contribution that should be topped, and you should be able to claim that if you are of past pension age. If you became pensionable before April 2016, that should be backdated to the date you became pensionable. I have been claiming assisting individuals outside the UK since 2013 with claiming their pension from the UK, or some pension from the UK. And in many cases, those individuals would not have met the minimum threshold, which is 10 years, in order to get pension from the UK. However, there is a loophole where in some cases, even when that individual has only worked for a year in the UK, they can get some pension from the UK. It's not going to be the full state pension. It will be proportionate to the amount of national insurance contribution that you're paid. I say all that because when it comes to state pension and claiming state pension, I do have a good indication of what should be done and what can be done. During the 60s, 70s, right up to the 80s, there are quite a number of individuals who came from Commonwealth countries into the UK, stayed here for 5, 6, 7, 8 years, and then they moved on to America and Canada. It was a done thing then. Went over to Canada, they went over to the USA. Lights are a lot bigger, brighter, and broader there, so they stayed in the USA. Those 9.5 years, 6, 7 years, 3 years, whatever they did in the UK, they have totally forgotten about the UK. A lot of cases, they can get some pension from the UK. As I said, I've been doing this in 2013, 2014, assisting those individuals. Some cases have had 10,000 up to 40,000. One particular lady that came here, went to Canada, is outside the UK, I'm not going to say which country. She applied to the pensions office here. She did 9 years, 9 months. She was 3 months short. There's ways that that lady could get that 9 years, 9 months proportionate amount of pension. That lady is well over 80 years old, and it would be backdated to her 60th birthday, whenever that was. So that lady would possibly accumulate over 28 years of pension. So the maths would dictate that. Gary, Karen, back to you. Can with near enough 4 o'clock now, we need to make a few announcements. One of them is that we're gonna be in the House of Commons in September again. Keir Starmer sent out a video sometime last week, early last week, I think, stating that should he win, he will make changes to the Windrush scheme, made a number of promises. I have chosen not to circulate that video because at the end of the video, it says vote Labour, and I do not want to be endorsing any particular political party due to me promoting the Windrush scheme and, well, etc., etc. That video is out there. I would suggest you have a look at it if you can. We are hoping that whichever party wins, that they will get some changes. One of the changes that we would like is for the scheme to be taken out of the hands of the Home Office, because we think it's counterintuitive for the Home Office, the wrongdoer, to be dishing out restorative justice, so to speak. But also, the scope of the scheme needs to be widened. Scope of the scheme, I believe, needs to be widened even before it's taken out of the hands of the Home Office. I did mention the scenario to you earlier on with the grandchildren, the lady who lost her house, who locked out of the UK, went over to Ghana. I used Ghana, it wasn't Ghana, I used Ghana instead of mentioning the actual country. Went over to Ghana, out of the UK for 3 years. Child had a nervous breakdown, grandchildren were living with her, and those grandchildren were impacted. However, there is no category in the scheme for those grandchildren to make a claim. The children can make a claim as a close family member, however, not the grandchildren. If a close family member passed away, before they make the close family member application, that claim, so to speak, would pass with that individual. unlike a primary claim. With a primary claim, next of kin or the executor could make that claim under the deceased estate category of the scheme. We are of the belief that that close family member claim should be treated just like a primary claim should a close family member pass. We also believe in-laws should be able to make a claim as close family, should be able to make claims as close family members. Prior to the 23rd of April this year, there was no category in the scheme for stepchildren. Now stepchildren can make a claim. We brought it to the attention of the Home Office on numerous occasions, stating that it doesn't make any sense that stepchildren can make a claim. Prior to the 23rd of October last year, those individuals that were born in the UK and lived outside the UK for whatever reason, and in many cases they approached the High Commission outside the UK, in Ghana, Kenya, etc., and they were treated with hostility. Consequently, despite the fact that they were born in the UK, had a British passport, had the right to be in the UK, they have been locked out of the UK for years, and in many cases, decades, like one particular lady in Barbados as we speak. There was no category in the scheme for those individuals. I raised it with them, brought it to the Home Office attention a couple of years ago, and I was told it's only a few. Anyway, on the 24th of October last year, not down to myself, I'm not taking the credit for that. I think primarily it was down to a judicial review that Home Office was taken to court sometime last year in September. As of the 24th of October, those born in the UK and lived outside the UK, those that did not continue to live in the UK, can now make a claim to the Windrush compensation scheme, to the Windrush scheme, because there's a category in the scheme for them now. Gary?
Thank you. Yes, so we've come to the conclusion now, to the end of our Sunday chat. Just a couple of things before you leave. In the chat, we have Roland has put a contact number and also a email address directly. So if somebody wants to pick up any further one-to-one after this, then please reach out. Also in the chat, you will find our website, justiceforwindrushgenerations.co.uk is there. And you will find the advocacy website, which is liverpooladvocatesforwindrush.org. Again, email address, telephone number, contact page is there for individual needing any help or with the application process, etc. Please reach out for the help. Don't just say, well, I'll just do it myself, and it'll be fine. Get somebody to have a look over it and just to make sure it's okay before you submit, because we want your claim to be successful rather than a nil award. So please use the support available so that we can help you. Now, we also do this twice a month, so it's the second and last Sunday of each month. And then in between the first and third Sunday is the law Q&A, where we answer questions specifically around any query on the compensation scheme, or anything that you as an individual want to know. We always encourage question be submitted 48 hours before each session. The Q&A session is next week. So again, if you look at the website, Justice Liverpool Advocates for Windrush, you will see how to submit a question that we can research if we need to find an answer and get back to you. We're also in the period for Windrush commemoration some celebration is also taking place at this time. The Windrush Day, which commences on the 22nd, right through to August. There are events taking place all over the country. Check your own city. You can visit windrush100.org and see events there. See what's happening locally that you can attend. And, please avail yourself to this information. And of course, we have various WhatsApp group that people are getting information and keeping track of what's happening around Windrush and what's happening in relation to events and conversation, etc. So there are plenty of opportunity for information. What you've heard today, please share with other people that, there's help available. A lot of people still don't understand Windrush. And it doesn't have, Caribbean people don't understand Windrush. People from the rest of the world don't understand Windrush. Africans don't understand Windrush. Asian don't understand Windrush. So please share information with other people. Windrush is a global issue affecting people from 65 countries. So please let people know that. It is not a Caribbean or a Jamaican issue. It is a global issue. And with changing the narrative that's out in the public domain, that Windrush is Caribbean only issue. Doesn't matter how you arrive in the UK. A lot of people didn't arrive on the ship. I didn't arrive on the ship. What's important is dates. And we've said this, the timeline for Windrush is 1948 to 1988. That is the timeline. So that's the period that's referred to as Windrush generations and descendants. We're now in 5 generations of Windrush. And even those who are born in the UK who think, oh, Windrush got nothing to do with me, I'm not affected, until they apply for a passport to travel and it's refused, they probably will never think Windrush is of any importance to them. So please share information and let people know we're here to help. We're here to help you. We're not paid to do this. This is 100% voluntary. We do this because it's affecting our community, it's affecting our people, and we're here to help individuals to get through this difficult period around Windrush. So thank you very much for your participation this afternoon. Sorry?
Can I make a quick
Yes.
announcement before you go?
Yes.
If you know of anyone that has applied to the scheme, whether as a primary claimant or a deceased estate, and they
We lost you there. Yeah. I think we lost Roland. His must be internet has gone out. So yeah, we reached the conclusion of our session. But if anybody would like to reach out to Roland, as said, the contact information is there. But he's also put, if you know anyone who have an offer for a primary or deceased estate claim, please encourage them to make a close family claim. And that's what we've been saying this afternoon. As soon as somebody receive an offer, the primary claimant, then close family can submit claims, right? Very important. As soon as an offer is made for the primary claimant, close family can submit claims. And we said claims, no number restriction. Doesn't matter. Submit claims. Thank you very much. Have a good afternoon until we meet again. So enjoy the rest of the afternoon. So bye for now. Mimi, we'll talk afterwards.
Oh yeah, no problem. I got your email.
Yeah,
and I
that's right.
responded.
Excellent. Thank you.
Thank
Okay,
you.
that's all right. Enjoy. Yeah. Bye-bye for now. Mm.
Mimi, can you hear me?
Mimi, can you hear me? Mimi, can you hear me?
Hello, Mimi.
Yes, I can hear you, Roland. There seems to be some sort of echo.
Yeah, no, it's my I had two devices running.
Okay.
Would you like us to call the gentleman now?
Yeah, no problem. Let's try. What about Charlene and Ivy? Would you like to ask any questions?
Well, we're over now. I'm gonna leave it running in the background.
Okay. So, right. Let's have a look. Okay, so what will we do? We'll log out of this now, shall we?
Let's log out. I'm gonna leave one device running in case
Oh,
there's anyone attend late. So I'll log out on this device and then
okay, I'll
I
leave
will
this
call
device
you.
as well.
Okay.
No problem.
Okay.